Hello everyone, my name is Sanya Mahajan. I'm a legal intern in LEXIS company, and today's topic of mine is upon the Article 20 of the Indian Constitution, which provide protection against the conviction of the offences. And Article 20 of the Indian Constitution provides for the protection respect to the conviction of offences. In other words, it lays down that certain safeguard to the person accused of crimes as stated below, that is ex facto law, that is Article 20 clause 1, and then there is double jeopardy, that is Article 20 clause 2, and self incrimination, that is Article 20 clause 3. Ex post facto law, Article 20 clause 1 states that it is a prohibition, and the expression ex facto means a law which imposes penalties and convictions on the act already done and increase the penalty as. In other words, the ex facto law imposes penalty retrospectively. For example, the Dowry Prohibition Act 1961, which came into force, and when a person guilty is of accepting dowry is punishable under section the particular act and before 20 clause 5. And there is ex facto laws are of three kinds as follows: a law which declares some act or omission as an offense, and for the first time after the completion of that act or omission, and a law which enhances the punishment or penalty for an offense subsequent to the commission of that particular offense, and a law which prescribes a new and a different procedure for the prosecution of the offense subsequent to the commission of that offense. Article 20 clause 2, which provides that no person shall be convicted of any offence except for a violation of a law in force at the time of commission of a particular act which is charged as an offence, nor be subjected to any penalty greater than that which might have been inflicted under the law in force at the time of commission of the offence. And there is example to it. If a person commits an offence in the year of 1947 as per the act, in that year the punishment was imprisonment for fine or both for the same act, which was amended in 1949 and which enhances the punishment of the same offence by an additional fine. In such a case, punishment enhanced would be applicable to the act of 1947 and the same would be set aside. Thus, Article 20 clause 3 states about the self-incrimination. Self-incrimination means conveying information based upon personal knowledge of the person, giving information involving himself to be the prime part of taken in the offence. A person shall not be asked to make statement against himself, that is self-harming statement or the confessional statement. Clause 3 of the Indian Article 20 of the Indian Constitution prohibits self-incrimination. It states that no person accused of any offence shall be compelled to be a witness of against himself. And Article 20 clause 3 is based upon the common law maxim, that is nemo tenure procure separism, which means no man is bound to accuse himself. And the written must be, that is the person seeking protection under clause 3 of the Article 20 must be accused of an offence. Secondly, the protection is against compulsion to be a witness, and he is compelled to be given witnesses against himself. Then third is the compulsion against the relates to giving evidence against himself. And further we can see that the article under Article 2 20 clause 3 and clause 20 clause 2 ingredient is compulsion to be witness and compulsion to be given evidence against himself. Both the ingredients can be understood through the various sections under the Indian Evidence Act 1872, which states as follows: that is, according to section 25 of the act, confessional statement made by the person accused of the to the police officer is inadmissible. Thus, Article 20 is designed to protect the people against the excess of the legislative and the judiciary and executive respectively. Guys, this video was all about Article 20 of the Indian Constitution, and if you need any information related, please do write in the comment section. Please do subscribe this channel.